Okay.
All righty, very good. Well, I'm going, as I said earlier, going to get into the land use aspects of some of the things we've been talking about during Eric's presentation. I'm going to review some areas mainly for context at the beginning because I think you're probably familiar with a lot of the framework in South Carolina related to land use and land use decisions. But I wanted to cover some of these areas, cover a couple of cases, just so we're familiar with how the way that you make decisions, the way that your boards make decisions can play out in a judicial situation if it were to arise. So just to start at the very top, we have, of course, the South Carolina Constitution, which includes with it a number of areas that you're very familiar with, or at least have heard of, I'm sure, related to fundamental rights and county government, local government, eminent domain. Those all come into play and are constitutionally based. We go to the statutes, we've got Title IV that addresses counties, 5 cities, 6 local government in general, and it's within Title VI that we get most of our planning statutes. As you can see there, Chapter 29, the Planning Enabling Act, this is what sets forth rules related to the Planning Commission, its creation, comprehensive planning process, zoning, land development regulations, creation of the BZA, the Design Review Board, et cetera. In addition to these, you've also got the Development Agreement Act, and then, of course, vested rights here. That's the statutory context within which my presentation will sit. Again, starting at the top of your hierarchy with the council, when it comes to land use, most of the decisions the council will make are what we've called legislative. They fall in that legislative category. The things that can be considered, the procedural requirements for legislative acts are different from those that are considered quasi-judicial or adjudicatory in nature. So the council, as you know, adopts a comprehensive plan or comprehensive plan elements. It adopts zoning districts, zoning district changes, whether it's to the text or to the zoning map. These are legislative actions, and it can adopt land development regulations. I'm going to spend a bit of time talking about ex parte communications with respect to quasi-judicial hearings, which in South Carolina mainly relate to the BZA, can apply to the Planning Commission and can apply to the council as well. But typically speaking, you're in a legislative type of context. So I want to look at a case here to give you some sense of how this can play out. This is a rezoning case in Kershaw County. There's a situation where the staff recommended approval of a rezoning request of a parcel that was about 90 acres. The Planning Commission also recommended approval of the rezoning, and the council denied the rezoning amongst a big citizen outcry. In fact, as I recall, it was a unanimous decision to deny the legislative rezoning of the property. In response to some of the comments that were made during the first denial, the applicant submitted a traffic study, provided that to staff, made a second rezoning application, and that was also the subject of a recommendation of approval by staff and recommendation of approval by the Planning Commission, but once again was denied 6-1 by the council a second time among citizen opposition. In this case, the land developer challenged the decision to deny the rezoning in federal court, and the federal district court upheld the denial of this legislative ruling. And it distinguished in this case a legislative action of council from quasi-judicial decisions in local government. And what that means is that the standard of review is very lax. It means that as long as the decision is fairly debatable, if there's anything that would support that decision, the courts are usually not going to intervene or supersede the decision of local government. It's a legislative matter. It's inherently the nature of that branch of government for the courts to stay out unless a fundamental right, a constitutional right is implicated, or there's really just abuse of power, essentially. So they applied the fairly debatable standard, and they saw in the record some evidence of the reason that the council overturned that same case. We turn to the Planning Commission. As I said, most of the Planning Commission activities are advisory in South Carolina, are not quasi-judicial. They can recommend to you, or they do recommend to you, plan elements or the comprehensive plan or plan updates. They appoint advisory subcommittees. This is taken directly from the statutes. They can hear appeals from staff determinations related to plats and plans. So this is one that could fall into the area of a quasi-judicial determination, and this is related to land development regulations, which include subdivision in South Carolina, not zoning determinations by staff. Those go to the BZA, which we'll get to here in a second. Planning commissions can approve land development plans and plats in South Carolina. That can include site plans and typically plats as well. Planning commission decisions on plats and on appeals are final. So that means that appeals from a planning commission decision on a subdivision go straight to the court. Does not.
So doesn't that make it quasi-judicial, since that aspect of it, since the town council does not have the ability to legislate?
Right, that's a very good question, and we'll get to that in a second, and it's a surprising answer. So in Kirshner v. City of Camden, we had the Planning Commission looking at, let's just go through this for a second. So we're going to talk about substantive versus procedural due process. I won't bore you with substantive due process, but with procedural due process, it typically requires notice and opportunity to be heard in judicial review. Now, in local government settings, unlike judicial settings, strict due process and all the things that are required in a judicial setting are not necessarily required, just fundamental due process. So generally these three areas. But the court held that a subdivision application is legislative, discretionary, and not adjudicative, and therefore not a quasi-judicial decision. Now, this is interesting for a couple of reasons. One is, as I suspect Councilman Belt's getting at here, is that's a decision on an individual application, and it is taken straight to court. So they are applying the law and making a determination here, but that's where our courts have fallen on this to this point. So the court basically, as I said, does not, said, these types of hearings, since they're legislative, do not require trial type hearing in a legislative context. So hearsay is allowed, voir dire is not required to be allowed, cross-examination is not required to be allowed. So long in this subdivision situation as there's any evidence, this is sort of the any evidence rule or fairly debatable rule, to support a zoning decision of a zoning board, the courts are going to uphold that decision.
So planning commissions can deny subdivision. They can simply choose to, as long as there's some basis.
Correct. According to this case, that's right, where we are right now.
They do not have to approve, okay?
Now, there are criteria in the ordinance that will guide that decision making, but I assume that goes without saying. All right, let's get to the Board of Zoning Appeals. This is the body in South Carolina that is going to be always acting in a quasi-judicial framework. They can hear appeals from administrative decisions. This is zoning decisions I mentioned earlier. They can grant variances, of course. They can grant special exceptions. Their decisions do have to include written findings and conclusions, and this is something else that distinguishes BZA opinions in a quasi-judicial context from the council's decisions in a legislative context, unless there's a local rule that requires findings be made. The statutes haven't required that for rezonings. So these proceedings are quasi-judicial, and appeals from the BZA, unlike in some states, go directly to circuit court. So I'll look at this case here. It's a good one, I think, to consider, seeing the distinction between that Kershaw County case where the court was not going to touch it, where almost any evidence was sufficient, and here's one where the Court of Appeals reversed the denial of a special exception, so reversed the Board of Zoning Appeals related to its decision. Staff recommended approval based on the code's criteria. This was for a temporary, I believe, fireworks stand, and there was a lot of opposition from the community and from the neighbors, and they shared their concerns about property values, about traffic, about quality of life, and the BZA ended up denying the special exception request. But the court reversed in favor of the applicant, and they said this is a quasi-judicial decision and it was arbitrary and capricious, in a quasi-judicial setting, the board, the agency in that role, has to present or rely on competent substantial evidence to make those decisions, and this distinguishable from a legislative decision. Making sense?
So if, once they reversed it, could it be appealed again? I mean, just subsequent through the levels of court?
If it could have, this one wasn't. So.
So I'm a little bit confused about this.
Sure.
It's come up in arguably recent context. There are, in order to grant, there's a high bar for granting a variance.
Correct, there's specific criteria.
7 or 9 are specific criteria.
Okay.
You have to make an affirmative finding based on the evidence as to each of one of those
Okay.
to grant the variance,
Mhm.
approve the variance. So I'm not clear what happened here. Did they not, did they simply ignore all those and denied the variance request on completely unrelated reasons?
They did, it was a special exception out of variance. Okay, but it's a good question. So just some more background on the case was that the court said that the things, excuse me, the things that the members of the public, quote unquote, testified to required expertise and that they weren't competent experts to give testimony on property values and traffic. So they said in that context, I think the short note on this would be the BZA, anybody sitting in a quasi-judicial context can't deny based on, I would say nothing, but say just citizen objection.
Even though one of the criteria is a kind of a general public
It
interest
gets much more complicated when you look at that. Yeah, yeah, absolutely. Those are the ones that give me heartburn. Yeah. Okay, so quasi-judicial bodies, their role is to ascertain and investigate facts. They're sitting almost like a court, an informal court, you might say. They're conducting a hearing. They're weighing the evidence that must be competent and substantial. They are then tasked with drawing conclusions from that evidence as a basis for their official action. Meaning when that decision is being made by a quasi-judicial body, the record should reflect the basis of their decision based on the conclusions they've drawn, based on the evidence in the record, and also interpreting the law, that is the criteria there in the code that guide their decisions. The trick there, since it's not a political role, so to speak, is avoiding speculative, non-specific assertions of opinion and in the decision-making. So as in this context, we get back to the question of communication and how we communicate in local government. Here's where you're going to want to avoid communications outside of the public process in a hearing. These are called ex parte communications. And we have an AGO opinion from '97 that says that an ex parte communication, when acting in a quasi-judicial capacity, raises a presumption of prejudice. That is, you've communicated outside of the public hearing, and the assumption is that there is some prejudice there. So, what do we mean by ex parte communication? Eric referenced some of the local governments in South Carolina that have adopted codes of conduct or codes of procedure. I'm going to reference a couple here in a minute. The city of Hardeeville has actually codified a definition and guidance on ex parte communication. So what the language they've used is that it is communication outside of a duly noticed open hearing on the record at which all parties and decision makers have an opportunity to be present regarding any matter pending before or which may reasonably be expected to pend or to be before that decision-making body. So the idea here in a quasi-judicial setting is it's like a trial, that if I'm the one making my case, the applicant, I should know what you've considered to make the decision on my application. Not so much the case when we talk about legislative. That's policy-making, lots of discretion in that regard for the council. But if you're deciding my application and I've put forth evidence, so to speak, in my application for why it should be supported, staff has responded to that, you've talked about that, if you're a quasi-judicial body, it's inappropriate to bring in something you heard at the coffee shop that morning on this case that nobody else knows about, and I can't rebut as the applicant. Everybody follow me on this? Okay. So that's the idea. So again, we've mentioned this, but we're talking about your variances, your special exceptions, appeals. Anything else is considered a final decision on a development application. I think in one of our preliminary calls, Joe, you may have mentioned, I think the council looks at license applications, business licenses?
Yeah.
Okay.
Well, that's standard.
Okay, and that's good, you handle that as a quasi judicial matter?
Yes.
Okay, so that would be an
That's-
example, when the council's sitting that way.
The point is, that's a unique situation for council. So
Right.
usually y'all are legislative. There's one instance I know off the top of my head where you're judicial. That's a business license hearings, right? Where we would like not to be, involving outside ex parte communication.
That's right.
In that situation. Not something y'all have to usually worry about, but in that one instance. It could potentially come to play.
Sure, and so that's a good contrast, I think, for the council. It can result in the decision being reversed. Now, we'll get to this in a second, but we can, if there's ex parte communication, it can be cured, and sometimes it's harmless. So that's just something you have to deal with as part of the process. So a decision is voidable, this is according to the city of Hardeeville. It's voidable if the decision maker engaged in a substantive written or oral ex parte communication with a party or person who has a direct interest in any issue in the matter. So this would be sitting, say, as a BZA member, and you're considering a variance application, and the person's neighbor comes and speaks to you at the coffee shop, tells you information about the parcel that everybody doesn't know, but you think, well, this is sort of relevant. Let's say they're asking for a 10-foot variance, but they really need 15 because they've violated something else. That information needs to be disclosed at the meeting, that communication occurred, the nature of the communication, and it gives the applicant a chance to say, oh, okay, I'm glad you brought this up. Let me tell you about that shed. It actually isn't illegal, and I brought a photograph. It's only 7 feet from the line or whatever it is. So there is a way to cure that. And in Hardeeville, there's a prompt notification of the parties. They make it part of the record, and they give an opportunity to rebut. So I mentioned earlier that there's some of the jurisdictions where I work have a more developed body of law on some of these processes. Florida is definitely one of those. Florida has a very developed body of law on what's quasi-judicial and what's not. It's called the Fasano Doctrine that the South Carolina courts tried to adopt, but then failed to. And we can talk about that more if you want to. But so in Florida, the concept of ex parte communications with respect to quasi-judicial hearings is very well developed. So it's not unusual for me to be at a client meeting in Florida at a quasi-judicial hearing, and they start off by saying, has anybody had an ex parte communication? So, the confusion can arise that ex parte communication is just on its face corrupt or something, and it's not. It's just an opportunity to disclose it, talk about it, because as you've noted today, sometimes y'all hear things you didn't, or boards hear things they didn't ask to hear. You get an email out of the blue and that sort of thing. So there is a way to correct it. To that point, I wanted to mention there are a couple codes of conduct. One's a code of conduct, and that's Isle of Palms. And I want to just mention their situation very quickly here, since it's a South Carolina situation. The Isle of Palms last summer adopted a code of conduct. I think it's an interesting read, and we can be happy to provide it. If it actually is hard to Google, but I can send it. I had a hard time finding it, but I'm happy to send it to Stephanie. As you read through their code of conduct, and the council adopted this, they answer some of the questions you brought up with Eric this morning. I can tell by the way they wrote it that is because there was no clear answer, and they wanted a clear answer in the Isle of Palms for what they expect in terms of behavior and communication. So that's a good resource. The other one I would mention is Monroe County, Florida, where I started my career as a planner, by the way, which of course colors some of my thinking on this. Monroe County has a code of procedure, very, very detailed. What I like about it is it talks about exactly how a quasi-judicial proceeding, for example, will be conducted. Staff goes first, applicant goes second, public goes third, and then the planning commission has deliberation. Applicants are not allowed to question a single member of the planning commission. Have to direct questions to the planning commission or to the chair. Applicants can't question staff directly, things like that. I think what it does for these commissions is it allows them to enforce not just a civil environment, but a procedure that is fair, that is transparent. It seems very credible when you witness it, even though it seems a little formal. But it also puts the public on notice of why certain things are being done. So for example, this came to mind when the councilman mentioned the email disclaimer. If a constituent, for example, Eric, correct me if I'm saying something idiotic here, but if a constituent got an email back from an elected official saying, this is how we handle public comment, and they would then understand why perhaps they're not hearing a reply, or they're hearing a reply in a certain way from you. They're getting that up front. So there's no suspicion or there's no dereliction of, political duty or whatever could be associated with it. So point being, I can also provide Monroe counties. I think they're both, each of these is are good resources and worth the read. They're only 3 or 4 pages each. I'd peruse them. I think they'd be of benefit. And I think that's what Hardyville is trying to get at here. If we put it in writing, we won't solve all problems, but maybe we'll solve more.
Before you
Sure thing.
move on, I
Yeah.
do want to come back to make sure I understand what you said, maybe what the implications of the Kirshner decision are regarding the planning commission. It's a legislative function, not a quasi-judicial function, so there's greater latitude in essentially the planning commission being able to make a decision.
That's what it seems to be that court was saying. And
So, under our ordinances, and this comes up in 2 or 3 different places, the planning commission can approve, disapprove, or approve with conditions. So they have the latitude to disapprove a subdivision, a preliminary subdivision, or final subdivision plat application. And they can do so based upon, I assume, the purposes, the underlying, as long as they're related to the basis of denial to the underlying purposes of the subdivision ordinance, which include provide for the harmonious development of the town. So if the planning commission determines that, and they outline the reasons why it's not, in their view, consistent with the harmonious development of the town, they can disapprove the application.
I'd be a little bit reluctant to opine on the town of Kiowa's language there. The only qualifier, I know what the course said. It says subdivisions in South Carolina are legislative. We did have a case, I think in the late 80s in Richland County, where a court said that so in Florida, for example, a single parcel being rezoned is quasi-judicial. That's not a legislative decision in Florida. So the applicant gets all the procedural protections that they would for a variance in Florida. There's a presentation of evidence. You can cross-examine. If a neighbor gets up and speaks against your application, the applicant can question that person as a witness. That's for small lot zonings. That makes some sense if you think about it, because they're making a determination for one parcel. It really is adjudicative in nature. That court found that, this was the Court of Appeals found that, it opined anyway, that a single parcel, small scale rezoning should be quasi-judicial. The Fasano doctrine should apply in Florida. When the case went up on appeal in the Supreme Court, it was ultimately dismissed, but the court said the comments that the Court of Appeals made relating to the Fasano doctrine were dicta, meaning it's not a basis of its decision. Then we have an Attorney General opinion, and this is important to point out, where the Attorney General said that the Planning Commission can be acting in a quasi-judicial format or form at times. Now, there's not enough detail from that opinion to know what I think the city of Georgetown had raised to the Attorney General. But my point is I'd be cautious about saying their discretion is unfettered, maybe even to the point of, a zoning policy it would be. But we have this case. It's worth, that's what we know. Okay, so the Planning Commission recommends the planning elements, that's advisory. The council adopts it, that's legislative. We know that. When it comes to zoning text and map amendments, the council's making the final decision following the recommendation of the Planning Commission. Those decisions, this is another way of putting it, carry a presumption of validity. Again, legislative decision, when you're making decisions about the zoning map or the zoning ordinance, the burden is on the applicant to show that the decision of council, the legislative decision, was not even fairly debatable. There was no evidence to support it. When it comes to subdivisions and plats, subdivisions in South Carolina are within the land development regulation section of the statutes. They are considered a land development regulation, along with the other things I'm listing here. So these are handled differently from jurisdiction to jurisdiction. There are jurisdictions where a planning commission will look at what they call a sketch plan or a site plan or a preliminary plan, and that may be distinguishable from a plat. And then you get in the whole world of plan developments, and local governments around South Carolina each require different things and levels of detail when it comes to plan developments. So we get into that world as well. So it can be quasi-judicial if it's looking at something like a decision made by staff. And in these cases, there has to be a record of the decisions and grounds for the decision that's maintained on file. Any questions about the land use areas I've covered before we get into?
I just
Yes,
have
sir.
one. So if an appeal is made for a variance to the Board of Zoning Appeals,
Yes, sir.
and the circumstances of that variance application are determined to be within what the law says they can do, then am I correct in that the Board of Zoning Appeals can't legitimately deny that just because somebody doesn't like what is being applied for?
That's the general rule. Or to flip it, I would say its decisions have to be based on substantial evidence in the record that those criteria have been met. And I think that's what happened in the Kirshner case, the Wyndham Estates case, where the only thing in the record was opinion from the neighbors, which wasn't competent and substantial.
But if it is all competent, and somebody says, well, I don't think they need a garage, that's not a valid reason to deny it.
It may get to one of the criteria related to hardship, and so I'm reluctant to say, but yeah, what's
But
that?
typically, that would not be a competent thing, just, they've never had a garage, why do they need one now?
Yeah, you're getting
That's
to the point of, right.
All right.
But I think some of those, go ahead, Joe.
Well, I think the point is when you start getting that kind of stuff on the record, that is something that's gonna make a judge pause before he just rubber stamps the appeal, which frankly is what's gonna happen a lot. That, appeals just don't, unless there's something really amiss,
Yep,
the appeals are usually
pretty
not
routine.
gonna be granted. But as is demonstrated by that case, I forget the name of the case, you never know what's gonna get their attention.
Right.
And in that situation, there was a feeling that it was just, I guess, a lot of neighbors complaining about a situation, and when that becomes weighed against them checking all the other boxes, then, that's gonna get a court's attention.
Okay.
So, to that point, and I'll try to make this a little bit more hypothetical than specific. One of the concerns I've had, but I haven't served on the BCA, Russ, you have, correct? Is whether there is a sufficient appreciation on part of the BZA members as to the quasi-judicial nature of that process and function, and the requirement requirement that there actually are, to order to grant variances, there are, I think it's 9, I don't remember exact number, specific criteria, uniqueness, apart from general hardship, and there's a whole bunch of other things. And the question, you know, if for example, the one BZA member says, well, they just didn't consider other alternatives, the applicant. And everybody says, oh, you're right, they really did, denied. When that's not one of the criteria, and arguably all of the actual statutory criteria, there was evidence provided that they met that, that would probably be challengeable. That would be the type of thing where potentially a court would challenge.
And it's important to remember that that case was not a variance, it was a special exception. And the variance, the nice thing about the variance is you have the 8 factors to follow, and frankly, if you look at how we process those, and it's how a lot of cities do, I think it's best practice. I mean, it is very focused on those factors.
Well-
And when you do that, I mean, you are providing yourself a lot of insulation from any
So
potential.
I've only listened to a couple, 3, and I might respectfully argue that while the planning director's recommendation focuses on those factors, the discussion that follows amongst the BZA members may depart pretty far from those factors. And they actually never themselves, the adjudicative body never actually makes the findings with respect to those factors. And that's where I think the potential concern comes in, that I would think that the body itself should be going through systematically and saying, the BZA should be saying, yes, uniqueness, the evidence supports that, we agree that factor is met, and going through each one of those factors. But that's not what happens.
I'm not sure that's what happens anywhere.
Okay,
But
okay.
again, my point is, if you have a record of using these factors, it becomes harder and harder for any court sitting as an appeal and reviewing the decision to say, oh, y'all really went off the reservation here, and we're gonna send it back.
Yeah, and my concern, again, just given the way one recent matter kind of was discussed, my personal view is not all of the factors were met, but the decision by the BZA, they started articulating reasons to deny other than related to the 8 factors. And does that type of scenario cause any potential problem?
I can't answer that any way other than I already have. I mean, it may or may not, depending on what the rest of the record is. Again, I just think that it's quite common that the discussions I've heard on the BZA are not unusual in what, and I really kind of feel like that situation with the Kirshner is distinguishable. I mean, mainly because it's a special exception, you don't have this whole list of factors going on. But, I mean, there's gotta be some stuff that catches someone's eye for them to really decide they need to redo this. And I'd like to, I mean, just going back to the planning commission situation, and I think what you're talking about is when planning commission is reviewing applications for extensions on plat approvals.
Okay.
Yeah, I was actually just the preliminary subdivision plat application itself, and/or the conditional plat approval or the final plat approval. At any step along the way, it appears, at least my reading of our ordinances combined with what the court's holding is, and I'm reading it right here in Kirshner, is that it's a exercise of discretionary authority as opposed to an adjudicatory power, and therefore the planning commission as a body would have the authority to approve or approve with conditions or deny the application at any step along the way.
Well, I would just ask Tyson what he has to say. review, what is the interplay between the state law and that discretion?
But the state law mirrors the language of approve, approve with conditions, or deny.
Yes, but
In Kirshner?
subdivision applications in accord with our Vested Rights Act, does that limit the discretion of the planning commission?
I would, I've noticed today that it's very easy to advise on what is clearly safe. Yeah, I think that, I would not say that the discretion is unfettered. I wouldn't say that about a rezoning, but it pretty
I
much,
wasn't suggesting it's unfettered, I was tying it to the underlying, the stated purposes of the subdivision ordinance, which I don't know if that tracks the state statute as well.
that case, I think, says that if the planning commission has relied on the criteria in its ordinance, that the court is going to be loath to second-guess that decision in a legislative context, which they said this subdivision approval was. Now, I don't recall right off, I assume this was preliminary subdivision approval. You know, just as a matter of general law, we regard final subdivisions to be ministerial. Everything's resolved by that point. They've just gotten their bonding and performance guarantees and improvements put in, and the staff can, you know, approve that. So I don't know how far along each of those categories I go.
Even though the same approve, approve with conditions, or deny attaches to each step of it along the way in the ordinance itself. You're saying that the general view is, at least once you get to final, it's ministerial.
As long as they have sufficiently articulated the conditions, the planning commission in this case, and the staff has verified those have been met. That is the general rule.
So let's take a little time check here. So we're right at 2 o'clock. We have a Ways and Means Committee that starts at 3. So I'm not sure how much more we have to do.
I'm not sure where we're at, because I know you said there's another.
Yeah, he probably wants to at least get through this. I think this will be helpful based on the discussion I've heard so far.
Okay. And
Okay.
this is basically at the results and remedies was the last kind of.
We're at the end, yeah.
Yeah.
I'm not trying to cut you off.
Huh?
Well,
Move on?
yeah, hold on, yeah.
Okay.
We're at essentially the last piece of,
Okay.
Okay, very good. Eric?
I don't know if there's any other questions for, but when they come up. Results.
Yeah, don't go anywhere.
So we talked about what happens if we do something wrong. So, and this is a very general, you know, we're reorienting back from the planning context specifically to the overall context. And so big picture is when, let's just say in this context, you've committed a violation of FOIA. The minimum remedy for a violation of FOIA is an injunction. You violated FOIA. Don't do it again. It almost always results in an award of attorney's fees. I want to emphasize that in some cases, a violation of FOIA can actually invalidate the resulting action. And there's several cases on this, but one case I cited is Business License Opposition Commission or Committee versus Sumter County. And I just have the quote where the court said, "We find no abuse of discretion on the part of the master in ordering the equitable relief of invalidation of the ordinance." So what this case stands for is that when the court is looking at an alleged violation of FOIA, whether it's having a meeting, we had the question earlier, what if you have an unnoticed meeting in violation of FOIA? The mild remedy would be the court would say, you did something wrong, don't do it again, pay attorney's fees. The draconian remedy, which they have the equitable power to do in ordering an injunction, is to say that actions that resulted from that unnoticed meeting are invalid. So let's say that you had that unnoticed meeting, you discussed a matter, subsequent to that meeting, you took legal action on the matter. The court does have the injunctive authority to say that ordinance, that resolution, that vote of council is invalid, doesn't exist. So something that we worry about a good bit. I think that what you'd find is that remedy would be used when there's been an intentional violation. And if there's been an intentional violation, there are also minor criminal penalties for violation of FOIA. You probably know this. There's also the possibility, I guess now that it's not criminal, they've amended it, civil fines now, rather than criminal penalties. It would be civil fines. Generally, you know, tying into the discussion, one thing that can happen is you can compromise and appeal. So if there's a violation of FOIA, if there's ex parte communications, evidence of improper influence over the body, then it could undermine the municipality's position on appeal. And I'm citing the same, I think it's the same Attorney General opinion you cited, rebuttable presumption of prejudice if there's an ex parte communication. I want to, I mean, Tyson is a land use lawyer, I'm not, so I want to defer to his expertise, but my kind of layman sense on what happens with a land use decision, when are they invalidated, given the general deferential standard? And I think this applies to any context in which the courts are going to defer to the legislative prerogatives of counsel. What's really a problem is basically based on the evidence that's considered. So, you know, it may be that the evidence is not competent, that you've reached a decision, but the evidence is not competent because it's offered by a member of the public and it's not competent evidence. It may be that it's evidence that's not available to the parties or the public in advance of the meeting. That would be an ex parte communication. One of the things that troubles me, this is probably not relevant in Kiowa Island, but it's certainly relevant elsewhere, is it can also be a problem if evidence is introduced that's not disclaimed or rejected. A case that I think about a lot, it's a Fourth Circuit case. I think it was Virginia or Maryland. Land use decision came to the body. It was on siting of a mosque, and the council had adequate reason under their zoning ordinance to deny the siting of the mosque at the location. Legitimate non-discriminatory reasons, but the public came to the meeting and a bunch of really obnoxious things were said by the public at the meeting about, we don't want these people in our community, 9/11, et cetera. And then the council denied the siting of the mosque, and the court said, it doesn't really matter if council had adequate reasons to do it. Basically, the record, this is the shorthand way of saying it, basically the record's tainted because they received this evidence and didn't affirmatively disclaim it or shut it down or whatever. So the theme I want to make here, like compromising the appeal, is you always want to think about the quality of the evidence that's in front of the body. Has it been presented to the public? You know, has it been communicated behind closed doors by ex parte communications? Has it been, is it competent? You know, things like this. And so what I'd worry about is, you know, these kind of violations. One thing that can happen is you compromise your appeal and you lose the deference you would ordinarily get when something goes up on appeal. Any questions on that, or does it make sense? Due process violation, which would, in theory, you know, invalidate an action as well. Procedural due process, Tyson told you this already. Notice, a reasonable opportunity to be heard in a fair hearing. These are all adjacent issues. You know, if it's a violation of FOIA, embedded in that is the concept, part of that is a due process violation because the public has a right to know as part of the notice and opportunity to be heard. So unlawful actions, ex parte communications, improper influence could be a violation of due process. This is where my slide on the Surfside Beach case is. Complaint under the Ethics Act, if you know, personal interest is implicated. What they found in the Surfside Beach situation was that respondents in violation of the Ethics Act for knowingly representing a person before a unit of the municipality for which he had official responsibility. The situation there is, I've already told you the facts of this, but the situation was he's a council member. Council has the right to appoint the members of the BZA. Therefore, he has official responsibility for it. And it's interesting to me. I don't know that I would have guessed this result, but by appearing in front of the BZA and advocating for an outcome in the case, they said you represented the applicant. And if you'll remember, I said, even though that council member didn't have a relationship with the applicant, wasn't being paid for it, it wasn't whatever. The flip side of this is that you can represent before a body if it's your own personal affairs, if it's your property. So the difficult thing, I think, to navigate, and the question that's not been answered, is if you cannot appear in front of the BZA to advocate for one outcome or the other, what about communications with the BZA that aren't making an appearance in front of the body? Do you follow me? And I don't know the answer to that. The Ethics Commission is very difficult to predict these days. I think they would look askance at it. So I think it would raise two issues. One, does it compromise the appeal for the reasons we've talked about? And two, is it potentially an ethics violation on your own part for representing the applicant or representing against the applicant?
So if I have a neighbor that wants to do something that's going to cause it to go before the Board of Zoning Appeals, it is inappropriate for me as their neighbor to voice support for their request because I'm on council.
It's I apologize for having to say this again. It's difficult sometimes to draw the line because you have, so if you had an economic interest in it, then it would be an ethics
And let's
violation.
say I don't, but it's,
Yeah.
but to be safe, it would be inappropriate to do so.
Yeah, I think that, when you look at our codes of conduct, and we've asked, like, what are the common sense answers? I'm trying to give you all the deep in the weeds analysis law. What's the common sense recommendation? I say, my common sense recommendation is elected officials shouldn't communicate with the BZA or the Planning Commission about matters that are before them.
It's pretty simple.
Yeah, that's my common sense, because then you don't have to draw difficult lines.
Got it.
Now, there are times, if you're doing the comp plan, which is clearly a legislative thing, and you say, like, I'm an elected official, and I was elected to, by this constituency. I'm in Mount Pleasant, to take an example, and I'm not picking on Mount Pleasant, but, Mount Pleasant has a strong pro-growth and a strong anti-growth element, and every election they change. And if you were elected as a member of the Mount Pleasant Town Council, and they're working on the comp plan, and you communicate to the Planning Commission, I think we need to be more restrictive of new developments, and we need to take these things in the comp plan, that's probably okay. But I'd say that if there's any individual dispute going on, whether it's quasi-judicial or not, our prophylactic rule would be don't communicate. Because one, separation of powers. Those bodies are by state law created and they're given functions. Council's role with respect to a subordinate body is to appoint the members. That's your role. You appoint the members. If you don't like what they're doing, remove them, put other people on. Yeah, or change the ordinance.
Eric, can I ask a question?
Yeah.
For either one of you, because I think for us sometimes and we don't have rules yet around this, but when you talk about the legislative body being council should not maybe have certain communications with the members that they appoint, we have council liaisons. We have a liaison to a BZA, and we have a liaison to the Planning Commission. Historically, the liaisons' roles, they were not written, but really they just went to those meetings, and then they reported back to council what happened.
Right.
I think now with trying to understand exactly those roles, I would think it's, is it, appropriate, okay, for a council member that's a liaison to the BZA or Planning Commission that's sitting out in the audience, listening to the meetings, is it appropriate for them to speak up and go to the dais and talk about applications? Or can they just go to the dais and say, we want to update you all on things that the council is working on? I think for this group, just really understanding and defining that role, because we do have liaisons, and I think because we never had any rules, we had where application came up and we were trying to figure out how can they want to talk to the chair about it. Is it appropriate? Is it not appropriate? It became really kind of for us, we weren't sure because we never had that level of interest or participation. It was more of just kind of reporting, that member reporting to council, these were the things on the agenda. How does that, I don't know if other communities have that, because I never worked in a community that had that except for this community, and I'm not sure if you guys have an issue with it or not, or.
Was it Monroe or was it Isle of Palms that said you should not speak in front of a subordinate body, the council?
I'm looking at it now. So Isle of Palms has a section in its code called Independence of Boards, Committees, and Commissions. Because of the value of independent advice of boards, et cetera, to the public decision-making process, members shall refrain from using their position to unduly influence the deliberations or outcomes of boards, et cetera. Council members shall refrain from attending meetings of boards, et cetera, of which they are not members, to avoid the appearance of undue influence or FOIA violations. I would say inadvertent FOIA violations, maybe. Council members shall not contact board, committee, et cetera, members to lobby or advocate on behalf of or against an individual business, et cetera, on any matter that may or could likely come before the board. So yes, it's the independence of the board as a general.
So, but that last point you made, I think, is a critical one that may come before the board. To the extent that it's a BZA matter or Planning Commission doesn't come back before the council, then that would seem to be a different situation than what you just cited there. And part of the,
Not the whole paragraph, but.
well, at least the last sentence.
But the idea is that the influence appears not only because it may become before you, so it might compromise the integrity of your decision, but also because you have a point of power. I mean, that's where the root of the undue influence standard is that they are an independent decision-making body that may be compromised if if they feel like their appointments are at risk if they do something that an elected official doesn't like on a substantive matter.
So, and I'm trying to square that with the milieu that I've lived in
Right.
for a long period of time, which
Right.
is in the federal context, which,
Right.
and trying to square that with here. The idea that you would have an elected member of Congress who could not appear before any body, even where they have a point partner, whether it's an independent regulatory agency or otherwise, to advance their constituent interest
Right.
would be an anathema. I mean,
No, and I think the reason for that, I mean, it's a great point. I hope everybody followed it. I mean, but I think the reason for that is because we just have much more well-developed rules in the federal context. It's much clearer what is prohibited and what's permitted.
but you can do all that in the federal context.
Well, the reason you can do it is because the rules have evolved over time to say these are the very specific contexts in which you can do it. And here's where, here's the situations in which it's not appropriate. And the reason I want to say that, I mean, is because I'm not telling you that it's inappropriate to have any contact with the BZA. We have no case law on that. What I'm telling you is our prophylactic recommendation is if you want to be safe, the clearest thing to do is.
And I get that, and the last little point I make on that, it's just tough to square with one of the BZA findings, one of the criteria is a public interest
Right.
finding. It would seem that, the elected officials are kind of uniquely
Right.
positioned to have a view of what constitutes the public interest.
Yeah, and that's a good point, and we hear variations on that. The easiest variation to say is, I shouldn't lose my First Amendment rights to speak on issues of public interest simply because I got elected to office. And I think the best answer I can have to that is to say, you simply have a restricted forum. The forum is you address the public. You advocate, my position as an elected official, and you say this to everyone who'll listen to the public in a public forum is, this is what should happen, rather than communicating with members of the body or appearing in front of the body. But there still is there's no denying that there are some rights that are limited by holding elective office. And I think, to summarize all that, like, why would we give this prophylactic recommendation, let those boards be independent, is because you have this overlapping series of, we have the Freedom of Information Act, we have the Ethics Act, we have the ex parte communications, we have these possible remedies, that the safest thing, that what clearly the intent, I think, of South Carolina law is that these subordinate bodies are given free latitude to make their own decisions. And state law has determined what those are. And council should not seek to override that allocation of responsibilities. That's why I gave the separation of powers slide. What happens if you do? I don't know, because we haven't litigated that yet. And if it's interesting, something that Tyson mentioned, we don't have case law in South Carolina. What happens if you approve something that's inconsistent with the comprehensive plan? That's in litigation right now. We don't have, clear case law in South Carolina on what happens if a decision's made that doesn't satisfy all 4 or 8 or however many elements of the variance. That's in litigation right now. Hopefully we'll get reported decisions on this. One thing that's happened in South Carolina in my lifetime, I've been here my whole life, we've gone from a state where there's not a lot of land use litigation, there's not a lot of municipal litigation. The state is growing enormously fast now. Development is, we're going to see a lot more litigation. And I think that soon we'll have better answers on a lot of these questions. We're becoming more sophisticated because we're growing. So this last part is yours, right? The best practices part?
Yeah.
Okay.
Yeah, I guess the first point, and maybe this is just echoing what Eric said, I started off in local government working in a planning department. I would draft the staff recommendation for the planning commission. They considered variances in that context. And these were very separated, so that's my background. And I never felt like a bad decision was reached because everybody stayed in their role. So I think that's an important one. I think, as we've said, it's when you start creeping out of that for very good reasons. The frustrating thing here, of course, is it's your job to be well-informed, to advance the public interest, and you have a duty to your constituents. You ran on that, The challenge is balancing these other limitations against that. And then finally, I think you just can't beat the idea of a very advanced and very detailed set of rules of conduct and procedure. Something I'd recommend as well.
Well, great. Do you guys have any questions for this group? I know I have one that comes up regularly, and I know that we're always trying to figure out how to balance that, because sometimes I just don't know. And Councilmember Belt and I had this discussion last week, which is a meeting, as we had. Council members would like to be able to hear from the community. We have various, in this case, I'm sorry, go back. We have committees, board members, commissions that council has appointed. There's a lot of different initiatives that the council is working on that came from the planning retreat. And then the mayor may have then assigned individual council member projects. And as part of that, a council member may decide to essentially, bring in some more individuals, create a task force or a work group. And so our discussion became, ultimately, there may be recommendations up to council, there may not. It may have to go recommendations to the community association, we don't know. But when is a meeting when is a meeting when you maybe have only 2 council members, but then we have essentially formed like a task group or work group, and we may or may not have any recommendations to council. When do those meetings have to be considered noticed, or an agenda, abbreviated minutes, those type of things? And so we've had those discussions because we are looking at, we do create a lot of different work groups, but not officially, they're not officially appointed by council, but we do have council members participate in that. Brad?
So we have 2 specific things. We have one where, in an attempt to better communicate with our community at large, or give them the opportunity to better communicate with us, every Friday after our town council meetings, we have a session that is moderated by 2 council people, and it's an open forum. We have it in the back of this room sometimes elsewhere, and anybody in the community can just drop in and either ask questions, voice an opinion, bitch and moan about something, whatever they want to do. But it's to give them a forum where they can do that. So the question that Michael and I did, the first one, was that a meeting? It was noticed. We did take notes. He supplied notes afterwards of what went on.
And we published them.
And we published them.
Yeah.
And so was that a meeting, and did we do that appropriately? That's one. The second one involves Brad and myself, and that's more of a working group where we're doing it in concert with our community association, the homeowners association, where there are going to be 8 people on this working group, and we're going to try and resolve an outstanding issue with our architectural review board on how it needs to function and where it should be placed. And
I'm sorry, not ours, but the private architect review board.
yeah, not the towns. And it's part of the developers organization. And so are those meetings that Brad and I are going to have, are those public meetings? Do we need to notice the existence of those? It's just the 2 of us from council, and then everybody else is either, I'll say, an ordinary citizen or a member of the community association board. What's your feeling on that one? I think that one's a little harder
I think
than
it
maybe
is
this
harder.
first one.
I would think the first one is pretty easy, because a meeting has to be a quorum of the.
Well, and we're doing what would be necessary if it was, anyway. We're
Yeah.
notifying.
As if it is a quorum.
Yeah.
Yeah, on the first one, I think that's probably not a meeting, assuming that the other members of council aren't participating virtually, or that's probably not a meeting, but I would still give notice of it, because that's the purpose of having it,
Exactly.
is for people to know.
Right.
But the notice there is really more of a common sense, just do that so that people know you're having
Hope
it.
you, actually, the whole purpose of doing it is to have them come. And
Yeah.
there's no purpose to have the 2 of you talk, 2 of us talk to one another.
And then the things that result from that, and I've made this point before, that the public meeting rules are different than the public record rules. So the resulting documents from that would be public records. So if you receive communications, if you write minutes, if you say, here's what happened, those are public records, but you haven't had a meeting because there hasn't been a quorum.
Okay.
We decided to treat it as a meeting.
Yeah.
Announce the date, announce the location, announce the participants.
Right.
People can drop in within this 2-hour period.
There's no agenda.
There's no agenda, there's no presentation, people just drop in. But we are providing a brief summary at the end, that was Joe's recommendation at the time when we started this, which I think also is very pragmatic, because then everybody who was not at the meeting still knows what topics came up, right? What was discussed, and we make it very brief. Joe, you saw, I think, the first meeting before we published it, meeting minutes before we published it.
Okay.
I think that's.
I mean, this is one thing that I may disagree with Eric on. I kind of felt like it should be treated as a meeting. Obviously, the notice is not an issue, but what I did ask and what they're doing is that there's a very short agenda, because you can't really anticipate what people are going to ask, and some short minutes,
Right.
because that's how you check.
And we're doing that, so if it is or is not a meeting, it doesn't matter, we're erring on the side of treating it like a meeting.
Doesn't matter.
But Joe, I mean, Joe mentioned that, it may be a good thing to do, and in fact, we do obviously want to notice, it's the whole purpose of trying to get people.
Right.
But I'm still trying to figure out how that, what they did, meets the, looking at the statutory definition of a meeting, means the convening of a quorum of the constituent membership of a public body. And to-
Again, as I think Eric said, but he can correct me, is, my feeling is, even if it's not a quorum, if it's something that's, if something's gonna be discussed that ultimately comes before council for a decision, it should be treated as a meeting before your purpose.
And also what I felt, Brad,
But that's literally, it does say quorum.
I literally understand what you said, and yet, there is a wide belief,
Okay?
well, Eric, why don't you?
Well,
Well, I mean,
wait,
here's-
stop, let's don't beat this dead horse. The fact of the matter is, in this particular case, we're treating it as a meeting. We're treating it as a meeting. So if it is a meeting, we got it covered. If it's not a meeting, we're doing more than was necessary.
Yeah.
So I don't.
exactly.
but it-
And I think what we are doing,
The second point, that's why I want
that's-
clarity on that, because it
The
somewhat
second
relates to the
one's a
second.
different issue. I think it's a bigger, it's a little bit more sophisticated
is.
circumstance. We're just talking about this one.
right,
But I'm saying if it involves two of
No,
us.
no, no, no.
then the
We're
second
talking
one as
about
well.
this specific case.
it's not a quorum, I agree,
It's just this
but
specific case.
I think the concept we came up with serves the purpose.
Right.
Right? People are invited to come, they're notified, there's, well, we call it an agenda, which is not really, we start at 9, we close at 11, and please ask whatever question you have. That's the agenda, right? That's the purpose of it. And providing these very brief minutes, which also serves the purpose. I think what the trigger point for me was that although we have not a quorum, but we might make quasi decisions, right? I mean, if a member comes, a community member comes, has a complaint, and let's say, and we had that case where we both agreed, right? And because what he said in the meeting was absolutely right. We agreed and said, okay, we will take care of this by talking to A and B and see what we can do, right? So we made a quasi decision, or promise at least. So I felt actually comfortable then to say, we have done that in a quasi, meeting setup, right? Because a promise was made.
So I guess that's my point. We're doing everything in this particular setting as though it is an official meeting. And so there's nothing that we can decide that we need to do more to make it more like a meeting. The fact is, we're doing those things. So I think we're doing the correct thing in this particular case. Now, let's talk about this other one,
Just
though.
before
Why
we
not
do,
do it
that
the
you
same
were
way?
about to say something, Joe, or point to, there was something you were saying that notwithstanding the.
As Eric pointed out, there's an attorney general opinion that says you can't circumvent FOIA simply by not having a quorum.
Okay.
And there was a Court of Appeals opinion that said just what you're saying. If you don't have a quorum, you don't have to follow FOIA. And what happened to that Court of Appeals opinion? You recall? It was vacated by the Supreme Court in a very unusual manner.
Yeah, and
So I think every municipal attorney who has any amount of practice in this state, you can go ask them, can you circumvent FOIA by not having a quorum? And they're probably gonna tell you that's not a good idea.
yeah,
The problem becomes, is that, I mean, this is a rule that is debated and discussed ad nauseum all over the state, because it actually goes much, much deeper than that. Because the big problem that I see with the rule is then you start having staff meetings with one council member, and the problem is that Attorney General opinion arguably says you gotta even notice those.
So,
And these are paths that people go down everywhere. So there's a certain art to it, but I can tell you that I don't think anyone says it stops with, as long as you don't have a quorum, you're safe.
so and that, I understand kind of where that logic takes you, but then the issue is, what if it wasn't just two members? It's just literally one council member meeting with a group of constituents. So exact same dialogues occurring, the same kind of thing, I'm gonna follow up on that. So every time, I mean, it seemed if you're going down that path, every time a member of the council meets with members of the body politic to discuss anything that may ultimately come before the council, that should be noticed?
I don't know, again, there's an art to this.
Yeah.
And I think there's some factors to look at. I don't want to, I'm going, I'll answer it and Eric can answer it. I think if you have a formalized body that meets regularly, that has one council member on it, or anyone from the government on it, that's part of the decision-making chain, then you should start.
Well, first, I'm just saying, like, if because
So,
I
and-
want to have a
For the
brown
area.
bag lunch. No, I'm asking a question. I just want to have a brown bag lunch with constituents. Is that a meeting that needs to be noticed?
I think probably not, but I want to unpack a little bit of what Joe's saying, because I think it's the critical point here. You're calculating quorum by reference to a body. And the body is the body on whose behalf you're acting. And so in the case, the hypothetical that I got, I'm assuming that you say, okay, we're going to have a public input session and two members of council are going to attend that. And those two members of council may be X and Y at the first meeting, and they may be A and B at the second meeting. It rotates around, it's just whatever two council members are available. The body you're acting with respect to in that case is the council, and you do not have a quorum of council. And even if you take action at that meeting, you cannot take action on behalf of the body.
No.
You don't have the authority to take action
And
on
we are
behalf
not
of the
even
body.
taking actions per se, we're making promises
Now,
to
but-
take.
Right, but let me give a different example. What if you say we're going to, you say formally, we're going to constitute a public input committee. And the public input committee are these three members of council. And these three members of council, the purpose of the committee is to hold public input sessions where they keep records of the meeting. And then two come to that. You are having a meeting in that case, but you're having a meeting of the committee, not a meeting of the council. Does that make sense? And any committee. So in the first example, what I'm answering is, because this strikes me as essentially an ad hoc thing, a brown bag lunch, a public input session where two council members, as convenience allows, comes, that's not a meeting of the council, and you haven't constituted a committee. Now, if you do constitute a committee, the working group, the second hypothetical, I think if you constitute a committee, then a quorum of that is a meeting. And there's an awkwardly placed modifier in the statute. And I never thought when I was a young person that part of my job would be diagramming sentences. But you have to diagram the sentence because they're trying to capture two ideas in the definition of public body. One is a body that is unquestionably public. It's a city council. It's a government. The other is, what if you have a foundation? What if you have a related nonprofit corporation? What if you have somebody like the municipal association that itself is not a government? Is it subject to FOIA? Those bodies are subject to FOIA if they are supported by public funds. So in the middle of the statute, there's this language about supported by public
Full in
funds.
part by public funds or expending public funds.
And then after that, it says including any committee, subcommittee, or any other body. And I think that if you were to diagram that sentence out, the supported by public funds refers to the development corporations, to those private entities. But a committee, subcommittee, task force, anything else that's actually created by the council is a body subject to FOIA if a quorum assembles.
Okay, so,
I would read that, I would diagram it the other way. But
Yeah.
Okay.
But
So-
to complicate things a little bit to the point that the one John and I are talking about, it may hang a little bit on this public funds or not. It is not really a body that it's created and appointed by the town.
Right.
We said we're going to look at some architectural review issues, but it's a joint HOA town initiative. And so then the question becomes, is that joint initiative, and would it change the analysis if the KICA, the homeowners association, said, we're creating this thing. We'd like to have 2 council members participate.
I mean,
Put it that way.
I think it would depend on what, I can't draw a clear line here. I've used this word too much. Our prophylactic advice would be anything any constituent body of the council, it's 2 members of council serving on some other board as liaisons or whatever, even if it's privately created, if any part of that body's duties involve reporting back to the council what they've learned in their function, then I would say the safe course that a court would certainly protect would be assume that's a meeting, publicly notice it, and if you have a problem with that, then use the executive session provisions. I think that's what a court's always going to say is if you have to have this meeting and you literally can't discuss these things in public for whatever reason, then what you do is you give notice of the meeting, call the meeting to order, immediately go into executive session, have that discussion come out. But
So,
It doesn't lend itself to executive session.
Well, I mean, it might. We need to figure out whether we want to take that route or not. So I think we've got till the 17th to decide what we need to do.
Litigation strategy would,
but
that
but
could be litigation.
let's again, pragmatic, okay?
pragmatic.
Because I think we are starting to split legal hairs here again. So, I mean, a lot of these work group meetings that we are talking about, you know, the purpose of these meetings is actually to make them public, because we want people to know, and in several cases, we want even community member to participate. Something as you know, innocent like our Go Green initiative, right? I would prefer to have community members on that work group, right? I have no problem to make it public. I actually prefer to make it public because I know that is a topic a lot of community members are very interested in. So let them come and let them help us by announcing the meeting, having a little bit of an agenda, and providing, maybe not always with a newsletter blast, but I mean, have readily available on our website brief meeting minutes. I think it serves the purpose. And honestly, Brad, you know, also this ARB topic, no matter who is the leader, or who invites, etc., putting me as a community member, I would like to know what's going on and what is discussed, because it's a very, very crucial
And I
topic.
think that's absolutely right.
So going back and forth about these legal things doesn't help me at all. I think if we come to the point, you know, to say, let's be on the safe side, A, and B, let's be transparent. So let's treat them as meetings, even if that goes beyond potentially what we are required. I don't know. Treat it as a meeting, announce it, invite, provide a quick summary. That's what serves the
No
purpose we are
downside.
trying to
No,
achieve.
there's no downside.
There's no downside.
But I think the issue we're struggling with a little bit is at what point is it constituted and does that become necessary? To the fact that John and I sat down to have a discussion even before that they had KICA appointed with Donlin DeStefano, does that, or at least Donlin, does that, is it already constituted at that point? Or is it not constituted until we've added all these community members?
Yes,
I
and
think
that's
at
why I'm
that
saying,
point-
Brett, let's make that as a rule, right? Very simple. As soon as we have topics that are really, really important and interesting for the community, as long as we are including more than ourselves quorum or non, right? As soon as we want community members to participate, be interested in, ask questions, provide comments, etc., those for me would be the criteria to say, let's treat it as a simple meeting, announce agenda, brief meeting minutes, not necessarily, all audio
Michael.
and video, et cetera, period.
I think
That's
we're trying
very
to do
similar
that.
to
The
doing
reason
that.
for parsing some of this is trying to figure out exactly at what point does that trigger.
When do you use
Well,
it?
I just said that. The moment you
I know
have,
it's what you said. I was trying to figure
So-
out legally whether before that we actually needed to do so.
I haven't heard that.
That's why I was trying to kind of parse those.
So in this second example of this work group that's between some representatives from the town and the homeowners association, to Brad's point, he and I met on a very specific, it was a scheduled meeting that he and I met here on a specific day at a specific time to talk about kind of how we wanted to organize this group. Would that have been a meeting, or would it just been us trying to get our ducks in a row for how we wanted to organize subsequent meetings?
Yeah, well, you have this administrative concept, which I talked about earlier in that email discussion, if you're trying to set a meeting date. I mean, there is this concept, if you're meeting for administrative purposes, then that's not doing the business of the city. So if the administrative purpose is, we're trying to set this committee up, what are the rules?
Probably not.
Okay, that's what, we're trying to get some guidance
Yeah.
as to once
Okay.
we're constituted.
Now, on the question of these two members, the question that a court's going to ask is, has a committee been formed?
And that's what I'm trying to
And,
figure out.
and so, and the answer to whether a committee has been formed is going to be another one of these where it's on a gradation. If council has established a committee, clearly it's happened. The definitive case in this, which y'all probably have seen, is City of Myrtle Beach versus Quality Towing. What happened there was the city manager set up a procurement advisory board, staff members only. They reviewed RFPs for the towing contract. They had the authority to make a recommendation to the manager who would take it to the council. And the court said in that case, they had established a committee, even though there was no formal council action, even though no member of the body was on it, even though they had only advisory powers. So we use that as kind of our lodestar in when have you created a committee? And I think my normal advice, if I'm trying to keep people out of trouble, is if the purpose of that body, if it's a standing group, if it's two named members of the council, and the purpose is to receive information and report it back to council, a court is more likely than not going to find that a committee.
Okay.
And so.
That's pretty
But
clear.
committee, you're using the word committee only as a synonym, right? It can
Yeah,
be
I
a
mean,
work group, it can,
Yeah, what it says in the statute is committee, subcommittee, any other body by whatever name called.
Okay.
It's got, I'm not quoting language exactly.
No,
but
because I'm
just
asking
using the
because
term
we
committee as a
also
generic-
have,
right.
official appointed committees.
Right, no.
Right, so
It's-
that's why I
it's-
wanted to make that
it's-
distinction.
I would say it's any duly it's any constituted body. And constituted body would be, there's named members, and they have a function that involves reporting back to council.
Okay.
So,
All right, so we're getting close to when we need to kind of change gears a little bit here.
Just, you guys can just, if you have any last questions for Eric or Tyson, go ahead. We have,
I only
at
have,
least maybe, we probably should wrap up like at least 5 till or 10 till, so
I'd
that
say
we have
10
time to
up. Let's
transition.
We have 10 minutes.
10
okay.
minutes max. Yeah.
make Tyson answer some questions.
So I only have one question
Sorry,
again,
Tyson.
coming back to the role of the liaison for some of these committees, like the Planning Commission and the Board of Zoning, who are quasi-jurisdictional. Very difficult word for me. So I heard different things, and I just want to have that clarification. What can the liaison, or is the liaison allowed to do, and what not?
So we see different practices. What I believe the practice would be appropriate is the liaison, like this is again, a practical common sense suggestion. The liaison should not be a member of council, should be someone else, staff member, planning commission member, not a planning commission, somebody on staff, city staff or whatever. Now, if it is an elected official, the elected official would go to the meetings and not participate at all, simply listen and report back. That's the purpose of the liaison, is communications between the two.
Any subordinate body or just the quasi-judicial ones?
We're drawing lines here.
I'm the liaison to the Arts Committee, and I've been, Art Council, why?
There is a distinction between committees who are composed of members, has a seat for a member of council,
Right.
like the Arts Committee.
I think I'm just liaison.
We've moved away from that, so it's more staff. So the Arts Council, no, we don't have the Audit Committee And then the state ATAX, but they're a non-voting member. So that's
But
it.
the point is, those are different from a state law created or constituted body, like the BZA, where if a council member was on the BZA, that would be dual office.
So let's unpack, right, well, it depends, but let's unpack like the rules that Tyson talked about a little bit earlier. I mean, the problem with an elected official being the liaison is that we have said that the organic purpose of the law is to separate the powers of the constituted body, whether it's the BZA, the Board of Architectural Review, whatever, from council's functions. And if the liaison goes there clothed with the authority of an elected official of the council and participates in the meeting, then that could be perceived to be undue influence, representing a client before the body, whatever else. So if you were to adopt, the rule, it would say, how do you avoid that from happening? And what they said, I think it was the Isle of Palms, is the liaison, like no elected member of the body should go to those meetings. Isn't that what the policy said? And you say, well, that's not workable for us. I don't think that's legally required. That's a common sense safety rule. If you say, well, we have to have an elected official there at the BZA meetings, and I would say what that elected official is allowed to do is participate and observe and report back to the council. And you say, well, what if they stand up and say, well, the city demands that you follow your rules? I don't know. We don't have the answer to that. That's what I used to do when I was the city attorney for a city, is I would go to the BZA and I'd say, look, I'm here, I'm an attorney, but I'm not your attorney. I'm here just to listen. So, I mean, best advice I can give you is your liaison. You can have one. If it is an elected official, they should not participate in the meetings.
Okay, so there are two questions to exactly that last statement. First, at least speaking for the Planning Commission, you know, we have a standing agenda item where the liaison reports back to the commission, to the commissioners, from exactly where you're standing, what was decided or discussed during the prior day's town council meeting, relevant for the commissioners to know.
Yeah, and that's
So I
important.
step up there and I usually have 4 or 5 points of what was discussed. And I just, explain it. So,
Legally,
problematic
nothing wrong with
or
that.
not?
No, there's legally nothing wrong with that.
Okay.
The reason that people have, I need to
Second-
find another word. The reason people have the rule is because they may or may not believe that the elected official is always going to adhere to that process. They may also believe that even if the elected official does, it could lead to complicated evidentiary disputes and litigation. How do you know?
Okay,
that
now
they
you're
didn't
again
influence?
confusing
But-
me and I don't know
How
what
would that even
what the answer is. So again, my question, is it problematic, practically, is it practically okay to do what I just described?
Yeah, if all you're doing is reporting to them and receiving information, yes.
I mean, now I understand that one can say that I'm tainting the information, because what I believe, but I try to be as objective as I can as an individual and report. Sometimes they have questions, and then I answer them. Sometimes they just receive it. Many of them actually has probably even watched or being in the town council meeting so that they're informed. But that's what I do, and I kind of hear you that this is most likely okay.
Yeah, I mean, yes, it's legally okay.
Okay.
The risk
Second
is
question.
some member of the body says, councilman came to the meeting and by his body language or by otherwise tried to influence us, and then you have this evidentiary
It's
dispute.
at the very end of the meeting. It's basically Stephanie, the last topic or the second last topic on the agenda, I believe, right? When the liaison makes a statement, so all decisions are made, right? So there's nothing that follows after. So the influencing part is probably out of the picture.
I think it's fine.
Second question. I had 2 cases now where the council was starting to, let's say, get a little bit off track, let's say it this way, the commissioners, right, in their discussion during the meeting, okay? And I took the chance to stand up and say, guys, let's go back and make my comments. That I now feel was crossing the line.
Probably.
Okay, got it. That's all I wanted to know.
Okay, but,
All right, so Brad, I don't mean to be rude, but I think we need to stop because we need to get everybody prepared. We need to kind of make sure the room switches gears a little bit. We need to get off of this live stream and get set up for the next and so forth. So unless we've got something that we've not already talked about, let's call it a day and get ready for the Ways and Means Committee. It's okay?
Yes. Thank you.
We appreciate you guys coming. It's been pretty helpful, I think.
Very helpful.
So
Official